Great, thank you. This morning at 9:30 I met with the Governor. I recommended that the Governor should exercise the royal prerogative of mercy and grant Ms Folbigg an unconditional pardon. The Governor agreed.
5 weeks ago, a second inquiry into Kathleen Folbigg's 2003 conviction determined there was now reasonable doubt as to her guilt. Following sustained pressure by Folbigg's supporters, the New South Wales Attorney-General agreed to act before Tom Bathurst's findings are handed down.
Considering Mr Bathurst's conclusion that he is firmly of the view that there is reasonable doubt as to Ms Folbigg's guilt, I consider that his reasons establish exceptional circumstances of the kind that weigh heavily in favour of the grant of a free pardon, and that in the interest of justice Ms Folbigg should be released from custody as soon as possible.
Ambulance emergency. I need an ambulance. My baby's not breathing.
In 2003, Kathleen Folbigg was sentenced to 40 years for the murder of 3 of her children, Patrick, Sarah and Laura, and the manslaughter of Caleb. With no direct evidence to drive the prosecution's case, the Crown relied heavily on the coincidence of 4 children dying in the same family and the words in Kathleen Folbigg's diaries. It was enough to secure a conviction.
Mrs Folbigg wishes me to say on her behalf that she is innocent of killing her children or in any way harming her children. She's instructed me to lodge an appeal immediately, and that will be done today.
On appeal, the conviction was upheld, but the sentence reduced to 30 years. All the while, Kathleen Folbigg maintained her innocence.
Are you responsible for the death of Carla?
No.
Are you responsible for the death of Patrick?
No.
In 2015, Folbigg's lawyers called for a review into her convictions, based on new findings by forensic pathologist Professor Stephen Cordner. 3 years later, New South Wales Attorney-General Mark Speakman recommended an inquiry be established to review the convictions.
This is not a decision or a recommendation that I have made lightly. It has weighed on me and it has been an immensely difficult decision.
Former Chief Justice of the District Court, Reg Blanche, was appointed to head the inquiry.
The Crown case relied wholly on circumstantial evidence.
Folbigg's former husband, Craig, opposed her release.
This chapter unfolding now, we feel, was unnecessary and most definitely unwelcome.
In 2019, the Blanche inquiry delivered its findings.
After an extensive public inquiry, Commissioner Blanche found that there was no doubt about Ms Folbigg's guilt, and indeed he thought that the evidence before him actually reinforced his view that Ms Folbigg was guilty of those 4 homicides and that malicious infliction of harm.
Folbigg's supporters continued to push for further reviews.
90 of the country's top scientists and doctors believe she should be a free woman. The group says new technology suggests that Ms Folbigg's children could have died of natural causes.
In March 2021, the group sent a petition to the Governor, calling for Folbigg to be pardoned.
A new attempt is being made to free Kathleen Folbigg. A public inquiry is investigating whether new genetic evidence might prove that she's innocent.
In April, counsel assisting concluded there was doubt over the convictions.
Your Honour, the ultimate submission of counsel assisting is that on the whole of the body of evidence before this inquiry, there is a reasonable doubt as to Ms Folbigg's guilt.
Tonight, Kathleen Folbigg is a free woman, pardoned by the state of New South Wales, but not yet exonerated.
We've got a husband and wife who lost each other, a woman who spent 20 years in jail, and a family that never had a chance.
The work of Professor Carla Vinossa helped lead to today's outcome. New evidence about the existence of a genetic mutation in the Folbigg family was central to this year's inquiry. Professor Vinossa is a Fellow of the Australian Academy of Science and currently a researcher at the world-renowned Crick Institute in London. Welcome to 7:30, Professor.
Thank you, Sarah. Nice to be here.
Now tell me, is Kathleen Folbigg's pardon a victory for science?
Yes, it is an incredible victory for science and for the many scientists that have worked very hard on this case for the last few years.
Now, can you explain what it was that you discovered that made such an important contribution to this case?
So we discovered a genetic variant in a gene called CAM2. This is a gene that has been shown to be able to cause lethal cardiac arrhythmias, so the heart can stop beating when the gene is mutated. And we found a variant that had never been seen before in any other individual in the world that looked very suspicious, very damaging, and that eventually was proven to cause this type of cardiac arrhythmias.
And how were you able to establish that any of the Folbigg children carried that gene?
So we were able to sequence DNA obtained from different tissues. In two of the children, we had a blood sample from the heel prick that's obtained when children are born. From two other children, there were other frozen tissues stored. And we now have these very powerful sequencing technologies. We call it next generation sequencing, where we can sequence the entire human genome, the 3 billion bases or letters of the genome. And using bioinformatic tools, we could really pinpoint and identify this variant as a very likely cause, which was then proven experimentally to cause arrhythmias.
Now, you say likely cause. How is it that the gene variant links to what happened to the children? How do you link the gene variant to an illness that in this case caused death?
So initially we could make predictions because it is a gene that does not tolerate variation. Every variant has shown to be not benign. Then there's also a history of other children that have had variants, particularly one family that had a variant in precisely the same residue, the same location of calmodulin, this glycine 114, in which a boy had died and a sister had suffered from a cardiac arrest. That is a very strong evidence that that particular position of calmodulin is pathogenic. But then the definitive evidence comes from testing the variant in the laboratory, in cells, looking at precisely the changes, in this case in calcium and other ions, that are responsible for the heart rhythm. And this research was carried out by 3 different laboratories in different countries in the world, led by a Danish group, the group of Professor Michael Toft Overgaard. Now, with all that evidence, we now have a very, very high likelihood that this variant caused the condition in these girls, their sudden death.
And in that case, we're talking about the 2 female daughters of Kathleen Folbigg, to be clear.
Yes.
And just help me understand this. So obviously none of this was known at the time of the 2003 trial, but how much of this was understood at the time of the first inquiry in 2019?
Look, at the time of the first inquiry, we didn't have the definitive experimental evidence. We had the predictions. The predictions that made it likely, but there was still a level of uncertainty. And it was only towards the end of the first inquiry and sadly after the hearings were conducted that we obtained this other piece of evidence of this second family where 2 children had been affected and there had been a death and a cardiac arrest with this other variant in the exact same position of calmodulin. Unfortunately, that came in late, so it couldn't be considered in all its depth. And we couldn't have the calmodulin experts in the courtroom to present that evidence.
Was there no possibility of delaying the inquiry or extending it to continue with this line of inquiry about this very important discovery?
look, there was that request put at the time, but I mean, I suppose this wasn't the only line of evidence that was being looked after or considered, and the decision was not to reopen the inquiry at the time.
This is complex science. Do you think that the system that exists in New South Wales is able to manage complex science, a debate like this, in a case of this difficulty?
Look, it is very complex science, and to be honest, I had my doubts that it could, but I think this current inquiry has shown very powerfully that it can be considered, but obviously there has been a few extra elements. The Australian Academy of Science has had legal representation in this inquiry, and through their role they could recommend experts that need to be cross-examined. They could oversee the process, really. And that's important because, as you say, the science is very complex. The technologies are very new. Even amongst medical experts, people have to be retrained to understand this new form of evidence. But look, I think to the credit of this particular inquiry, an enormous amount of time was dedicated to going very carefully through the findings, to interviewing a large number of experts and going in great detail through the science. And, you know, the barristers, counsel assisting, the judge seemed to understand what was being said and asked very pertinent questions. So I think that brings hope that, you know, there are ways in which the legal system can assess complex science. And I think probably more or some facilitation needs to put in place so that this is done routinely.
Now, in relation to the deaths of Caleb and Patrick, who, as I understand it, don't carry this gene variation, have you made any advances that could throw more light on their deaths?
Look, I think it's important first to remember that there were already medical causes that pointed to natural deaths. Caleb died at 19 days of age, but he was born with respiratory distress, which is unusual for a term baby. He then had problems breathing and swallowing simultaneously and was seen 2 days before his death, at day 17 of life, and he still had respiratory difficulties. They were put down to laryngomalacia, and he died 2 days later in a position that made his breathing even more difficult. In the case of Patrick, he developed severe epilepsy with blindness, and he died during an epileptic fit, and his death was put to an epileptic condition of unknown origin. Genetically, we have some interesting candidate variants, including one that has been linked to epilepsy, but we do not have definitive evidence, at least in part because we didn't have all the genetic information. I mean, we couldn't get a genetic sample from Craig Folbigg, for example, and that would have been important to prioritize the gene variants to look into.
Now, the New South Wales Attorney-General today decided to pardon Kathleen Folbigg, but a pardon doesn't yet mean that her convictions will be quashed. In your view, should they?
Look, I think they should, because Judge Bathurst has already alluded to in his memorandum to there being a very high probability that the causes of death were natural, and this probability has been there from the beginning. There's never been any evidence of the children being smothered or harmed in any way, and our genetic evidence points very strongly to the deaths of the girls being caused by a cardiac arrest, a cardiac arrhythmia. So I think it'll be a matter of time that the convictions will be quashed. Now, remember that in this particular inquiry, the judge can only conclude whether there is reasonable doubt or not. It is only in the Court of Criminal Appeal where the convictions can be quashed, and that will hopefully occur in due course.
Professor Vinossa, thank you very much indeed for giving us your time this evening. Thank you.
Not at all. Thank you, Sarah.